Welcome to Cordell and Cordell's Men's Divorce Podcast, moderated by Managing Partner and CEO Scott Trout, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Hey, welcome back to the Cordell and Cordell Men's Divorce Podcast. I'm Scott Trout, Managing Partner, CEO of Cordell and Cordell, and we continue to bring you the latest topics, information, things that you need to know that equip you to make really good decisions, to get to an attorney who practices exclusively in family law like we do here at Cordell and Cordell. And today is no different. As always, you need a initial consultation. This is not legal advice. It can't be. We don't know enough about your circumstances, your facts, your particular situation. You can only do that by scheduling a consult with a lawyer. You can do that with us, cordellcordell.com. You can go right to the website. You can schedule something right there online rather than talking to someone. But if you'd rather pick up the phone, you can do that. 866-DADS-LAW. So I'm joined by Jerrod. Welcome. We're going to talk a little bit about paternity. Welcome to the podcast.
Thank you. Jerrod Rayborn here. I'm in our Ridgeland, Mississippi office.
Yeah, sounds good. I couldn't tell from your accent at all where you're from in the South, so that's good. Although you may say I have that Midwest accent.
Well, you'll certainly hear it in the y'all, no doubt about that.
All right, paternity. Again, a legal term. We throw it around. You and I know exactly what it is. Let's start with really what that is. A lot of people do know, they've heard of it, but what is a paternity action? Let's start there.
About the definition of paternity action is basically dealing with any sort of child born outside of a marriage or born out of wedlock that's basically not born during a marriage.
And the idea of the paternity action is, there are a number of reasons we'll talk about establishing it and why that you would bring it. But I think the safest way is, how do you establish paternity? Because now we're saying, all right, there must be some legal way, but there's obviously a medical or scientific way to also establish paternity.
So there's a couple of different ways that you can establish paternity. It can be done by signing an acknowledgement, and which usually is a result of also being put on the birth certificate. Or the other way to do it is through DNA testing, which you go into the lab, they'll take the child in there, they'll take the father in there, and they will run the results. And then whatever DNA says, it's very rare for the lab to come back and give 100% absolutely certainty, but you'll usually get a 99.99, which is the same as 100. And then There you go.
So, it's interesting. We talk about, go get a DNA test. I'm the father. But sometimes, I've told clients in many states, there is nothing that protects the rights of dads just simply because you either acknowledge it, or you're on the birth certificate, or you may have DNA testing. And I know we're jumping ahead a bit, but it's so imperative to not just think that you can do any of those without a legal action to establish it officially, right?
That's right. Can someone voluntarily go to a lab and take testing? Certainly, but a lot of times it's not that simple, and you actually need to file an action with the court and serve them with a summons to get them compelled to go and do that testing.
Yeah, it could be you. Someone's claiming you're the father, or or presume you believe you're the father, and you want to know otherwise. So you file an action for DNA testing associated with a paternity action, or how do you do that?
That's right. You file just what's called a petition to establish paternity, and in Mississippi, you would file it in the Chancery Court, because that's what our family court is here in Mississippi. And there are various reasons for wanting to do that, but the biggest is just so that you can cut down on chaos. You can't get a court order until you've established paternity, and then you have to actually ask the court for an order to establish paternity. And then I want to see my child more. Well, you have to first establish paternity to do that.
Yeah.
But before that's done, it's not uncommon for a mother to play kind of keep away from the father and kind of dictate, this is when you can see the child and this is what you have to pay for when to see the child. And instead of just kind of being subject to the other person's demands, it makes sense to go and get a court order. And people say, well, I might lose custody if I do that. Well, you might win, right. But oftentimes, even if you lose custody, you're in a better position than you were before then, because at least if you lose custody, you'll have court-ordered mandatory time with the child versus before you had no time with the child.
Right. It was interesting. I mentioned kind of early on that typically absent a declaratory judgment that says you are the father, you have no rights. And in Florida, I was just doing a podcast with one of our attorneys in Florida where they just changed the law. And I'm curious about Mississippi. Florida now says there are rights that you can't deny someone who is the presumed father, who is acknowledged paternity, who's on the birth certificate, even absent a court order. You can't deny them custody. You could do that here in Missouri and pretty much get away with it. How does that work in Mississippi?
You can do the same thing in Mississippi, and that doesn't really even matter if you're dealing with a paternity action or a marriage. There's nothing that would prevent someone from keeping the other parent away from the child, and then there's nothing that would prevent that other person to go and pick the child up from school one day and then keep it, which puts the children in a terrible situation. And so that is the primary reason that you need a court order, is to cut down on, we call it the Wild Wild West, because that's basically right. What it is, or no man's land, until you actually get an order to follow.
So why, if I'm listening to you, why would I consider even filing first? What would be the impetus for me to say, okay, I should go file an action rather than waiting for my girlfriend or the mother of my child to file against me?
Well, in my state, the plaintiff is automatically entitled to reasonable attorney's fees if you're the plaintiff. So if you wait and let them file first because you might not want to pay child support, well, you might not have to pay child support initially then, but you are going to end up paying attorney's fees. Plus, you can get some of your attorney's fees reimbursed. And I've had some counties where they don't separate the two, paternity and custody, and they may award the full amount of the fee for the custody action. And then there's other counties where they'll cut those fees down to say $750 because they believe that that's all it would take to establish the paternity, and then the custody they treat as a separate suit. But if you want to automatically cut down on having to pay the other side's attorney's fees, it makes sense to be the plaintiff.
Such an interesting element of the law about fees, because I've told this story 30 years ago when I was starting my practice in family law. There was a provision in Missouri that the party that filed first was designated the custodial parent until further order of court. So we would oftentimes be in this race to get down to court to file first. And they did away with that law. Now it's interesting. I imagine you'd have this race to file first on paternity, because if you're entitled to fees, that's an interesting aspect.
I think it would be more so if more people knew that you can get entitled to an attorney's fees. But I have a lot of people that got served and then they come in and I have to explain to them on the back end, just so you know, they're going to be entitled to some attorney's fees. And they'll say, well, had I known, I would have filed first. And so I agree that if people knew more about that law, 100%. they would be running.
And that applies to divorce as well?
It does not apply to divorce. It does not apply
just
to
paternity.
That is just paternity actions. Yes.
Well, gosh, if you're a guy and you're watching in Mississippi and you haven't filed, go file. I mean, we can end the podcast right here, and it would be worth that. That's it. We just proved our value. But now let's think about, there's the positive. What should guys be watching out for in paternity actions?
Well, one is the issue of back child support. A mother in Mississippi can get back child support up to 1 year from the date of filing. Now, that doesn't mean 12 months, because you're not going to go to court on the day you file. Sometimes you may have to wait 5 or 6 months to get into court. So that could be 17 or 18 months. So that's one thing, is back child support, but that's not an automatic. We actually had a case come out in 2018 that says that the back child support is discretionary to the chancellor. And so you can make the argument, but you've got to be aware of it, because it's possible that you could end up paying back child support. But on that note too, I should say this: you get credit for anything that you actually did pay. And so it's important never to pay in cash. You want to pay in a method that can be proven, be it check, cash out, some sort of paper trail, because if you paid cash, you're not going to get a credit for it unless the other party acknowledges that you paid it.
Yeah. I mean, we call it, I think, necessities in terms of just getting some back support. It is something to be cautious. I mean, I've counseled guys, and they're not ready yet to file, but I say at least need to start paying some support. Or if you're buying things, keep receipts, whatever it may be. If you're buying diapers, you're buying this, that way we can show proof of necessities, just making sure. It's huge. So that's a big caution, because you can get hit with a very large child support back amount if you're not careful. One really interesting, I think, dynamic is people have often looked at paternity and marriage differently in terms of, and I've seen it even in judges, that you may have the same facts, but because the parties were married versus not, they made that this unconscious bias that exists. Now, does the law treat it differently? Maybe that's the question.
In theory, no. We use the same best interest analysis to determine custody, regardless of whether you're dealing with a child born of a marriage or a child outside of a marriage. But in theory, it doesn't always play out that way, because, like in Mississippi, we use the Albright factors to determine the best interest. One of the Albright factors is continuity of care. And a lot of times with a marriage, continuity of care may be treated more equally because dad was home at night from the very beginning. Whereas in a paternity action, mom has had the child the entire time, even though dad has tried to get the child. The continuity of care Albright factor would still put mom in advantage. So it can put you at a lesser advantage. Hey, Scott, something we were just talking about that back child support, I want to go back to.
Yep.
People shouldn't let that deter them from filing, because they're going to have to pay it at some point. And it is capped at a year from the date of filing. And it's usually whatever the arrearage is, they will usually only make you pay about $150 a month at most towards the arrearage. So, it's manageable. And then if your income's not high, it can be as low as $25 a month.
And you can get credit for money you've given. And
absolutely,
as long as you can prove it up. Right.
So that's right.
Right. So I think that's the good caution, as you suggest. Don't let this prohibit you from moving forward, because most guys out there are doing some contribution in some form or fashion. Other than cash is difficult to prove.
Labeling matters. If you send it and say kids Christmas, that may be considered not in the nature of food, clothing, and shelter, which is what child support is. So you labeling matters.
So let's talk about challenges. We talked a little about reasons why you should file. What are the biggest challenges in a paternity action?
Well, one is what we just mentioned, in getting over that hurdle of continuity of care. In a paternity action, you're behind in continuity of care, not necessarily due to any fault of your own. And one of the ways that, I think puts men on a more even playing field is preference of a child 12 or older. Obviously, when you're dealing with a paternity action, that's not going to come into play. And that's not a suggestion that you always want to put children in the center of litigation anyway, but sometimes it does happen. But that Albright factor of continuity of care, I feel like, plays more of a part in paternity actions than divorces.
And I get that question a lot. Can my child testify as to which parent they want to be with and spend time with or stay primarily with? And there are states around the country that set age limits. Georgia, when I practiced there at that point, many years ago, had an age minimum And then another threshold in which it was absolute, absent some sort of showing of unfitness. Missouri, we don't have that. Children can testify as to the wishes of their custodial parent, but it's instructive, but not absolute. The court can take it as evidence to consider, but it isn't a mandate. So I get a lot, and I rarely do. I've done it 3 times in my 31 years almost that I've been practicing, and for good cause. I don't like to do it. I think judges don't like it either. What do you say?
They definitely don't like it. I don't like to do it. I don't even like to get them to state affidavits of preference because, that's not as bad as making them going and testifying, but it's still putting them in the center of controversy. But to answer your question, no, judges hate it with good reason because the judge is tasked with the decision of making a decision of what's in the best interest for the children. And it's very rarely in the best interest of the children to be up there testifying, against one parent. We do not have an automatic bar as far as age of testifying, but to state a preference, they have to be 12. But if there's other issues that don't necessarily deal with them stating a preference, like if you've got an abuse situation or something bad has happened and the child needs to testify, they can be a testimony witness. But, the younger the child is even more reason for them not to be testifying.
Yeah. Exactly. It is difficult. You do it in camera in the judge's chambers, but that, it's something that stays with that child psychologically forever. It's a very difficult emotionally, and now they've chosen one over the other, and they may have to face that issue later on in life. And I get it. A judge is making a decision for you. They don't know you and they make mistakes, but I get the question a lot. And I try to resist that temptation, and I try to get the clients to resist it as well. I think there are much better facts and evidence to come out. Use other witnesses, teachers, friends.
Our guardian ad litem is another one. Is the biggest one to get them to talk to the kids, and you can usually get the preference that way.
Yeah, absolutely. Well, Jerrod, good stuff on paternity. There's plenty to learn, plenty more to know. So thanks for joining on the podcast today.
Thank you.
So if you want more information, give Jerrod a call. You can go to cordell.com. You can go to 866-DADS-LAW, schedule a consultation. That is really the only way to get advice on your particular circumstance. You can go to the website, find out more information about it as well at Men's Divorce or Dad's Divorce and cordell.com. So check out our virtual town hall in October, more information, but then that's live, where you can log in and ask questions of our panel of attorneys as well as our guests for the day. So check it out. It's free. All you have to do is sign up and attend during the day, usually around the lunch hour, and it's only for 30 minutes. So check out the rest of our podcasts on iTunes or on our YouTube channel and social media. Until next time, have a great week.